The photograph came in at 4:17 in the afternoon on a Tuesday, while I was still attached to a heart monitor, and the IV in my left arm had been there so long, the skin around it had gone tender. I was 80 years old, 17 days into a hospital stay that had started with chest pain on a Wednesday morning and escalated before noon into something my cardiologist called significant. And the image on my phone was my own front porch, my own fig tree visible at the edge of the frame, and a realtor's yard sign planted in my lawn like a flag. The text beneath it was from Eugenia, my neighbor of 31 years, and it said, "Harriet, is this right?" I had spent 29 years at Aldridge and Marsh reading instruments that other people found incomprehensible. I knew what a yard sign meant. I knew what a listing agreement looked like and who had to sign one and under what authority. I looked at that photograph for a long time, long enough for the monitor to register something, long enough for a nurse to look in and ask if I needed anything. And then I screenshotted it, created a folder on my phone the way I have always created folders, labeled it with the date, and saved it there. I did not call my children. I called Aldridge and Marsh. "Hello, friends. I'm Grace, and I want you to sit with what Harriet just told us. She's 80 years old, heart monitor on her chest, and her children are selling her house while she's in the ICU. But she didn't cry. She opened a folder and called her lawyer. Subscribe if you want to hear how this ends. I promise you, it ends on Harriet's terms." The house at 4412 Abercorn Extension has been mine since 1980. I bought it the year Carter was still in office, the year my youngest, Sylvie, turned 6 and Garrett was 9, and the mortgage rate was something I do not like to think about even now. It was a 1940s craftsman bungalow. Deep front porch, original heart pine floors that groaned in the same spots every morning. A fig tree I planted in the backyard that first spring because a woman in my office said figs were easy, and she was right. I paid that house off in 2003. It is assessed now at $340,000, and the neighborhood around it has been quietly becoming something different for the past decade, which I had noticed and which I understood had certain implications. I am not an uninformed woman. I came to Aldridge and Marsh in 1975 as a junior clerk, 29 years old, with a notary commission I had gotten through a correspondence course and a habit of reading every document twice before I touched a stamp to it. By the mid-1980s, I was doing title searches for the firm's residential closings, which meant going down to the Chatham County courthouse and pulling the chain of ownership on a property back as far as it needed to go to satisfy a title insurance underwriter. You are reading deeds, easements, liens, plats, court judgments, the whole legal biography of a piece of land. Most people find it tedious. I found it clarifying. I liked knowing the exact truth of a thing. After the cardiac event, I was moved from the ICU to a step-down unit on day 6, which is when I was allowed to have my phone back. Garrett had called twice a day from Atlanta. Sylvie had been in 4 times. She brought tulips the second visit, yellow from a florist on Broughton Street, and sat for an hour and talked about her daughter's school play and the new Thai restaurant on Bull Street and whether my cardiologist had said anything definitive about the timeline for discharge. She did not mention anything about the house. I did not know at that point that there was anything to mention. Eugenia's photograph arrived on day 17. I had just finished a cup of hospital coffee that tasted like it had been brewed in a radiator, and I was sitting up in the adjustable bed with the television on low, watching a cooking program I was not really watching, when my phone lit up on the tray table. I saw the thumbnail, and I picked it up. I expanded the image. I looked at it. The yard sign was one of those double-posted wire frames, the kind that goes into soft ground easily. It had the name of a development company on it. Not a residential realtor's name, which would have been unusual enough, but a developer's acquisition sign, the kind used when someone is buying to build or renovate rather than to occupy. I know the difference. I processed 100 transactions involving that type of sign in 29 years of work. I know what this document says. That is the sentence I have used internally whenever I am reading something that other people are hoping I will find ambiguous. I have found very little ambiguous in my life. That sign said someone had listed my house, accepted developer interest, and was preparing to convey it. My heart monitor registered something. I smoothed the blanket across my lap, took 3 slow breaths the way the respiratory therapist had shown me, and opened my contacts. Philip Marsh picked up on the second ring. I said, "Philip, it's Harriet. I'm in the hospital and I think someone has listed my house." He said, "I'll pull the title." That was the whole conversation, more or less. Philip has known me for 17 years. He did not ask me if I was sure. I signed the durable power of attorney in March of 2021, which was 2 years before this hospitalization, and 3 months after my internist mentioned, in the mildest possible tone, that it might be reasonable to have some documents in order given that I was 78 and living alone. I am not someone who resists practical advice. I went to my estate attorney, a woman named Rosalind Guthrie Falk, who works out of an office on Drayton Street, and I told her I wanted a straightforward, durable power of attorney naming Garrett and Sylvie as co-agents, to be used in the event that I was incapacitated and unable to manage my own affairs. I remember signing those documents clearly. I remember the quality of the light in Rosalind's office. North-facing windows, good gray afternoon light, a Tiffany-style lamp on the credenza that I had always thought was slightly out of character for her. I remember reading the document twice before I signed it, which is something I have done with every document I have ever signed since 1975. I remember the specific clause. My agents were authorized to manage, sell, or otherwise convey my real and personal property if I was determined to be incapacitated. I remember thinking, as I signed, that the clause was sensible and standard, and that I was being responsible rather than pessimistic. I was not wrong about any of that. What I did not account for was the speed with which Garrett would move. I did not account for the fact that he has spent 30 years in commercial property development in Atlanta, and that he has professional relationships with acquisition firms in multiple markets, including Savannah, which he knows well because he grew up here. I did not account for the fact that Sylvie, who visits me every other week and brings flowers from Broughton Street and knows the name of my cardiologist, would be the one to find an attorney willing to activate the power of attorney while I was still in the ICU. I signed a document in 2021 imagining a situation in which I was genuinely unable to manage my affairs. I was in a hospital bed with a heart monitor on my chest. My affairs were temporarily inconvenient to manage. Those are not the same thing. Eugenia came to see me the morning after she sent the photograph. She had driven herself. She is 77 and still has her license and her 2009 Buick LeSabre and her opinions about people who try to take those things from her. And she sat in the chair beside my bed with her hands in her lap and said, "I didn't know if I should send it. I didn't want to upset you." I told her she had done exactly the right thing. "The sign went up Friday," she said. "I thought maybe you knew. I thought maybe Garrett had talked to you about it. But then it sat there all weekend, and I kept thinking about it, and I thought, Harriet would want to know." Friday. The The sign went up on a Friday. I had been admitted to the hospital on a Wednesday, the Wednesday before last. That meant the sign had gone up 6 days into my hospitalization. 6 days after my cardiac event, someone had put a developer's acquisition sign in my front lawn. I did the arithmetic in my head, the way I have always done arithmetic, and I set it aside for later, and I told Eugenia she should go home and not worry, and I would handle this. "You're in the hospital," she said. "I have a phone," I said. She looked at me for a moment. Then she said, "You do, don't you?" She patted my hand once, the way she does, brief, specific, not sentimental, and she left. Philip called back the following morning, a Wednesday, at 8:45. He had started pulling the title chain the previous afternoon and had already gotten through the last 4 conveyances, which brought him back to 2003, and he would continue backward. He gave me the preliminary picture. The listing was filed with Chatham County. It was a legitimate filing, executed under the authority of the durable power of attorney I had signed in 2021, witnessed and notarized by an attorney named Bradley Covington, who practices out of an office on Montgomery Street and who had done everything technically correct. The listing named Ironwood Residential LLC as the buyer. Ironwood was a real estate investment company with offices in Atlanta, Charlotte, and Charleston. Philip had already looked them up, and they were entirely legitimate, which I had expected. They were not the point. They had received what appeared to be a valid listing from properly authorized agents acting under a properly executed power of attorney. They had no reason to question it. The offer price was $318,000. The house is assessed at $340,000. Someone, Garrett, almost certainly, with his professional knowledge of acquisition pricing, had priced it to move fast rather than to maximize return. $318,000. I thought about that number for a moment. I thought about the heart pine floors I had refinished in 1998 because the children were grown and I finally had the money. I thought about the kitchen renovation in 2006, the cast iron farmhouse sink I had found at a salvage yard in Pooler that took 3 men to carry in. I thought about the fig tree, which is now so large it shades the entire back corner of the yard from July through September. I thought about the closing paperwork from 1980, which I still have, in a file folder in the second drawer of my desk in the study, because I am the kind of woman who keeps things. $318,000. The closing was scheduled for 4 days after my projected discharge date. Philip said he would continue pulling the chain and call me back the following morning. I said that would be fine. I asked him whether he had found anything irregular yet. He was quiet for a moment, and then he said, "I'm getting to 1987. I'll call you tomorrow." I did not sleep well that night, but that had been true for 17 nights. The house on Abercorn Extension has had 7 owners since it was built in 1941. I am the 6th. A title search means going back through each conveyance, each deed, each transfer, each recorded instrument, and verifying that every link in the chain is clean. Clean means no gaps, no undischarged liens, no unresolved claims, no errors in the legal description of the property that might cast doubt on exactly what is being conveyed. One bad link and a title insurance company will not issue a commitment. Without a title commitment, a conventional transaction cannot close. I know this the way a person who has spent 29 years doing it knows it, not as theory, but as practice, as the specific smell of courthouse records rooms and the weight of a bound deed book and the particular quality of attention you need to catch the thing that doesn't quite match. It is not glamorous knowledge. It is the kind of knowledge that sits quietly until the moment it is needed. I did not spend those days lying still. A heart monitor does not prevent a person from thinking, and thinking is something I have always done in an organized way. I had my notebook. I had my phone. I had 29 years of institutional knowledge about how real estate transactions work, and specifically, about how they come apart. The cardiac event had been significant. Dr. Krishnamurthy had used that word twice, and I had understood him. But the significant cardiac event had happened to my body, not to my mind. And my mind was doing what it has always done, which is work. Philip called at 9:15 on Thursday morning. He had worked through the evening. He had gotten back to 1987. In 1987, the house changed hands for the second time since I had bought it. I am getting confused, let me be clear. I had purchased the house in 1980 from its previous owner, a widow named Mrs. Dolores Cantwell Reese, and my purchase closed without incident. But in 1987, there was an adjacent property transaction, a neighboring lot that was subdivided and partially conveyed. And in the recording of that transaction, a meets and bounds description was used that referenced an iron pin on the corner of the Abercorn property that was subsequently resurveyed in 1991 when the city expanded the road right-of-way. The resurvey moved the reference point. The 1987 deed was never corrected to reflect the new survey. It was flagged as a potential discrepancy, noted as likely immaterial to the main property, and filed. I had flagged it myself. I was 34 years old, working as a junior clerk, and I had caught a discrepancy in a meets and bounds description in a stack of routine filings and brought it to the senior attorney, a man named Harold Aldridge, the original partner, who had looked at it and said, "Good catch, Harriet. Note it and file it. It's immaterial to the main conveyance." I had made the note. I had filed it. I had not thought about it in 37 years. "Philip?" I said. "I know," he said. "The resurvey reference, the 1991 right-of-way?" "Yes. I'm looking at it now." We were both quiet for a moment. In 37 years, that discrepancy had never mattered. The property had been mine for 44 years, clear and uncontested. But a power of attorney authorizing agents to convey real property derives its authority from the legal description of that property as it exists in the recorded chain of title. If there is an arguable irregularity in that chain, arguable, not conclusive, then the scope of the power of attorney's application to this specific conveyance becomes a question rather than a certainty. And when there is a question, a title insurance underwriter has every right to pause. "Can we use it?" I asked. "I think we can make Ironwood's underwriter very uncomfortable," Philip said. "Uncomfortable enough that they pull the commitment while they investigate." "When is the closing?" 9 a.m. Monday. It was Thursday morning. We had 3 days. Philip sent his paralegal to the courthouse that afternoon to pull the original 1987 filing. He also, separately, requested the full listing documentation from the county recording office. The listing agreement, the purchase contract, the accepted offer. Everything that had been filed under the power of attorney. What came back was a timeline. The power of attorney had been activated with a letter from my cardiologist, not certifying incapacity, technically, but documenting that I was hospitalized following a significant cardiac event and was undergoing treatment. That documentation was sufficient, under the terms of the POA, to permit Garrett and Sylvie to act as my agents. The attorney they had used, Bradley Covington, had reviewed it and found it adequate. He was not wrong, strictly speaking. The listing agreement was signed on day 4 of my hospitalization. Day 4. I had been admitted on a Wednesday, moved to the ICU by Thursday afternoon, and by the following Sunday, While I was still in intensive care, while the IV lines were still being changed twice a day, and the nurses were checking my rhythm every 2 hours. My son and daughter had signed a listing agreement for my house with a developer Garrett knew professionally from his work in Atlanta. I sat with that for a long time. Day 4. The offer from Ironwood was accepted on day 9. I was in the step-down unit by then, which is where you go when you are improving, but not finished improving. The nursing staff there is excellent. The woman who brought my meals called me Miss Harriet and remembered that I did not like the orange gelatin. While she was bringing me trays, my children were negotiating a sale price. The closing was scheduled for a date that was, I noticed, precisely 4 days after my projected discharge. 4 days after I was supposed to come home. That was the detail that took me the longest to process. Not the listing, not the accepted offer, but the scheduling. 4 days gave them time to complete the sale before I had recovered enough to engage, but not enough time for me to realize what had happened and respond. Whoever had planned that timeline, and I believe it was Garrett who knows how these transactions move, had thought it through. This was not a panicked decision made by frightened children who loved their mother and made a terrible error. This was a plan. It had a timeline. It had a closing date. It had a developer contact Garrett maintained professionally. It had an attorney retained specifically to activate the power of attorney. It had been arranged piece by piece in the 9 days between my admission and the accepted offer, while I was in a step-down unit and a woman was bringing me trays and remembering that I didn't like orange gelatin. Philip filed the procedural challenge at 4:30 that Thursday afternoon. Friends. The listing was signed on day 4. She was still in the ICU. This wasn't children panicking. This was a plan with a timeline and a closing date built around her discharge. What would you have done in Harriet's position? Would you have been able to stay as calm as she did? I have thought about Sylvie more than I have thought about Garrett. That is not entirely fair, but it is true. Garrett, I understand, in the way you can understand a mechanism once you see it working. He spent his adult life in commercial property development. He processes real estate as a category of financial instrument. He looked at my house on Abercorn Extension, and he saw an asset in an appreciating market held by an 80-year-old woman who had just had a significant cardiac event, and he decided, in the way that developers decide things, that it should be liquidated while conditions were favorable. He told himself it was for my benefit. People in his industry often tell themselves things like that. It makes the paperwork easier to sign. Sylvie is harder. Sylvie drove 40 minutes round trip to visit me at the hospital on a Tuesday and a Thursday of the first week. She brought tulips. She sat for an hour each time. She asked about the timeline for discharge, which I now understand was not idle conversation. She was the one who found Bradley Covington. She was the one who called his office, explained the situation, provided the documentation from my cardiologist, and instructed him to proceed with activating the power of attorney. She signed the listing agreement herself. Her signature is on the document, in the blue ink she always uses, the loopy S, and the long tail on the P of Pruitt that I would recognize anywhere. I taught her to write cursive at the kitchen table of the house she was about to sell. She has genuinely believed, I think, that she was doing the right thing. That is the specific damage of Sylvie. Not calculation, but certainty. She convinced herself that her 80-year-old mother could not manage a valuable property alone, that the house was a liability and not a home, that I would understand eventually, that the proceeds would secure my future. She is not a cruel woman. She is a woman who made a decision about someone else's life and called it love. There is a particular kind of harm that comes wrapped in genuine care. I have seen it before, not in my family, but in my work. I have seen adult children of elderly clients sign documents that were technically legal and practically devastating, and tell themselves they were acting in their parents' best interest and mean it completely. The intent is sincere. The certainty is the problem. Sylvie was certain. She did not ask me. She did not need to ask me because she already knew what was best. That certainty is what I returned to, more than the listing agreement, more than the closing date, more even than the soup on Sunday. She was certain she was right, and so she did not have to wonder. On Friday, the day after Philip filed the procedural challenge, Sylvie called my hospital room. I watched my phone ring on the tray table. I let it go to voicemail. She left a message that was warm and specific and concerned about my recovery, and mentioned nothing at all, about what was on the calendar for Monday morning. I saved the voicemail. I labeled it with the date, the way I label things. I have a folder now with the photograph Eugenia sent, a screenshot of the listing documentation, Philip's procedural challenge filing, the voicemail from Sylvie on Friday, and the county records showing the timeline. I did not build that folder out of anger. I built it because I spent 29 years at a law firm, and I know what a well-documented record looks like, and I know that you keep what matters until it has served its purpose. Garrett, according to Philip's assistant, sent flowers to the hospital twice during my stay. Yellow roses, the same florist on Broughton Street that Sylvie uses. I appreciated the gesture. I kept the flowers and did not read anything into them. I have since learned that he was present at the closing location Monday morning, which was a conference room in Ironwood's Savannah office on Bay Street, and that he was there when Philip's procedural challenge was delivered. His face, according to someone who was there, went through several expressions before settling on something that looked like a man who had been very certain of something for a long time and had just become less certain. Saturday morning, 2 days before the closing. Philip called at 8. He had the full 1987 documentation in front of him, the original deed, the meets and bounds description, the junior clerk notation that flagged the discrepancy, and the 1991 survey records that confirmed the reference point had moved. He read me the property description aloud, the archaic language of meets and bounds survey notation, the iron pins and the bearing lines and the distances in feet, and when he got to the specific reference point, I stopped him. "That's the Oak Street corner pin," I said, "the one they reset in 1991 when they widened the right-of-way." He was quiet for a moment. "You remember it?" "I processed a similar one in 1994. Different property, same issue. A meets and bounds reference to a pin that had been moved by a subsequent survey. We held up a closing for 6 days while the title company investigated. They ended up issuing a corrective deed." "Harriet," he paused, "do you know that you are remarkable?" "I know what this document says," I told him. "What I need to know is whether Ironwood's title company knows what it says." The answer, as of Saturday morning, was probably not, because the 1987 notation was obscure, buried in an adjacent transaction rather than directly in my chain, and the kind of thing that a standard title search might miss if the searcher was not looking carefully. Philip's procedural challenge, filed Thursday, had raised the issue formally, but a procedural challenge takes time to be reviewed, and the closing was Monday at 9. Time was the variable we did not have enough of. Philip's plan was two-pronged. The challenge he had filed would continue working its way through the system. It was unlikely to produce a formal ruling before Monday, but it created a cloud on the transaction that would make any prudent underwriter nervous. The second prong was more direct. Someone needed to call the title insurance company's underwriter and explain, in specific technical detail, exactly what they were looking at. Not a formal challenge, a phone call. "Do you know who their underwriter is?" I asked. He told me the company. I thought for a moment. "I need to make one call," I said. "Who do they use locally?" Philip read me the name of the underwriting manager assigned to the Ironwood transaction. It was a name I had not heard in years, but recognized immediately. Constance Teal. She had been 27 years old when she walked into Aldridge and Marsh in the spring of 1996, newly hired by a title company that was expanding its Savannah book of business, and she had needed someone to teach her how to read a chain of title. That someone had been me. I told Philip I would make the call myself. He started to say something about whether I wanted him to handle it, and I said, "Philip, some calls work better without intermediaries." He was quiet for a moment. Then he said, "Yes, they do. I have a small notebook, a Leuchtturm 1917, hardcover, navy blue, the kind that comes with a ribbon marker, that I have kept beside whatever bed I sleep in since 2008. I write in it the things I need to remember the next morning, appointments, the names of people I have promised to call, the small administrative facts of a life managed carefully. It is not a diary. It is a working document. In the hospital, I had been writing in it since day 6, when the nurses let me have my belongings back. By Saturday, I had 4 pages of notes from my conversations with Philip. The timeline of the sale, the key dates, the technical details of the 1987 discrepancy, the name of Ironwood's closing attorney, the county recording numbers for the relevant instruments. I am 80 years old. I do not trust my memory the way I once did. I trust my notebook. I called Constance Teal at 9:30 Saturday morning. I had found her contact information through a professional directory Philip's office had access to, and I dialed from my hospital bed with the Leuchtturm open in my lap and the IV line draped carefully away from my writing hand. She picked up on the 4th ring, which told me she was in the office on a Saturday, which told me she was a serious person, which I had always known. "Constance," I said, "this is Harriet Alderman Poole. I trained you in 1996. There was a pause, and then, "Harriet, my God, I heard you were in the hospital." Word travels, in a town like Savannah, among people in connected industries. I had expected this. I told her I was in the hospital, yes, and that I was calling because I had a concern about a transaction she was currently underwriting, and that I needed to walk her through something in the chain of title for the property at 4412 Abercorn Extension. She was quiet for a moment, processing, I assumed, the peculiarity of the situation. And then she said, "Tell me what you're looking at." I told her. I told her about the 1987 filing and the adjacent transaction, and the meets and bounds description, and the 1991 resurvey that had moved the reference point. I told her about the notarized note in the original filing, the junior clerk notation, which was my own handwriting. And I told her the specific language of the discrepancy, which I remembered not because my memory is exceptional, but because it was the first significant catch of my career, and because that kind of thing stays with you when you are 29 years old and trying to prove to yourself that you are good at something. Constance did not interrupt. She made the sound of someone taking notes. When I finished, she said, "If this is what you're describing, the power of attorney's application to this specific conveyance is at minimum arguable." "It is at minimum arguable," I agreed. And you have Philip Marsh's procedural challenge already on file. Since Thursday. She was quiet for another moment. Then, I'll look at the chain myself this weekend. I'll call you if I need anything else. I thanked her and we hung up. I looked at my notebook. I had made one mark in the margin, a small check mark, the way I mark items that have moved from pending to in progress. I have been making that mark since 1975. It was Saturday morning. The closing was Monday at 9. We had 39 hours. Sunday was quiet in the particular way that Sundays are quiet in hospitals. The institutional rhythms slowing slightly, the day shift staff replaced by the weekend crew, the breakfast trays arriving later, and the hallways slightly less busy. My cardiologist came through in the morning, a compact man named Dr. Venugopal Krishnamurthy, who has the manner of someone who chose his words carefully before medical school and has been doing it ever since. He said my numbers were good. He said he expected to discharge me Tuesday or Wednesday. He asked if I had any questions. I asked if being on a heart monitor prevented me from making phone calls. He looked at me for a moment. Then he said, "No, Mrs. Alderman Poole, it does not." I had not told my children what was happening. I had made a deliberate choice about this on Thursday, after Philip filed the challenge, and I had not revisited it. They would learn what they were going to learn when the closing failed to close, and whatever conversation followed would be conducted on my terms, with documentation, in a register I chose. I am not a dramatic woman. I do not make scenes. I make records. Sylvie called again Sunday afternoon. I let it go to voicemail again. Her message this time was shorter. She said she hoped I was feeling better. She would try to come Tuesday. Love you, Mom. That was all. Tomorrow was Monday. Tomorrow at 9 in the morning, a closing was scheduled in a conference room on Bay Street that she had arranged. Her voice on the voicemail was completely ordinary. I thought about the fig tree in the backyard. I planted it in the spring of 1980, a bare root specimen from a nursery on Skidaway Road that has since closed. It is a brown turkey fig, the variety that produces twice a year in a Savannah climate, once in late June and again in August, and in a good year it will give me more figs than I can use in a month. I give bags of them to Eugenia. I make fig preserves in the old Kerr half-pint jars I have been using since my mother gave me her canning supplies in 1978. The tree is taller than my roofline now. It was 8 inches high when I put it in. The Sunday afternoon light in the step-down unit is a specific shade of yellow that I have decided I do not like. It comes through the institutional blinds in horizontal slats and falls across the floor tiles in a way that feels temporary, like light in a waiting room, rather than light in a place where you live. I had been looking at that light for 23 days. I thought about the south windows of the house on Abercorn Extension, the way the afternoon sun comes through the old glass at an angle in September and October, slightly imperfect glass that breaks the light into something just irregular enough to be beautiful. Old houses have that quality. The glass is not quite flat. Nothing in them is quite flat. That slight imprecision is what you are living in when you live in a house that was built in 1941 and has been inhabited continuously for 83 years. It is not a flaw. It is the record of time. I thought about who would inherit the fig tree if the house was sold to a developer. I thought about what Ironwood Residential LLC does with the properties it acquires. Renovate and flip, usually, or tear down and build new, depending on the market. I thought about the heart pine floors that took 3 days to refinish, and the cast iron sink, and the 1941 craftsman bones of a house that has lasted 83 years. I thought about Mrs. Dolores Cantwell Reese, who sold it to me in 1980 and had lived there for 32 years before me, and who had shaken my hand at the closing and told me the fig tree needed deep watering in August. Philip texted at 11:15 Sunday night. Constance pulled chain herself, confirmed the discrepancy. She'll call you in the morning. I wrote it in the notebook. I set the phone on the tray table. I looked at the ceiling for a while, thinking about nothing in particular, and then I went to sleep, which is the most useful thing you can do the night before something important. Monday. I woke at 5:30, which is when I always wake, hospital or not. The floor was quieter at that hour, the night staff finishing their last rounds before the shift change. I ate the breakfast that arrived at 6:30, eggs that were not quite eggs, toast that was not quite toast. And I had my notebook open and my phone charged, and I was ready when Constance called at 7 exactly. She had spent Sunday afternoon going through the chain herself. She had found the 1987 entry, the meets and bounds description, the junior clerk notation in the margins of the original filing. She had cross-referenced the 1991 survey records. She had called her firm's senior counsel at home Sunday evening. The conclusion, as of 7 Monday morning, was that the discrepancy was material enough to warrant holding the title commitment pending a corrective deed. A corrective deed would take, at minimum, several weeks to prepare, file, and record. You cannot close a transaction without a clear title commitment. Without the commitment, Ironwood could not fund. Without funding, there was no sale. "I'm pulling the commitment," Constance said. "I'll send the notice to both parties' counsel this morning." I thanked her. She said, "Don't thank me. You taught me how to read a chain. If I'd been sloppier, I'd have missed it entirely." She paused. "I hope you're out of that hospital soon, Harriet." It was 7:15 a.m. The closing was at 9. I set my phone down on the tray table and looked at the ceiling for a moment. Then I opened my notebook to a fresh page and wrote, "Commitment pulled. 7 a.m. I put a check mark in the margin. I want to tell you what I felt in that moment, but the honest answer is that I felt very little right away. The relief came later. What I felt first was something more like the particular quiet that follows the completion of a complicated task, the specific stillness of a woman who has done what needed doing and can now set down the thing she was carrying. Sylvie had visited the hospital the previous afternoon, Sunday, the day before the closing. She had come at 2 o'clock, which is visiting hours, and she had brought a container of she crab soup from a restaurant on Whitaker Street that I have been going to for 30 years. Proper she crab soup, the Savannah kind, with roe and sherry and heavy cream. The kind that takes time to make and that you bring to someone when you want them to feel cared for. She sat with me for an hour. We talked about Dr. Krishnamurthy and the discharge timeline and the weather in Savannah, which had turned warm early this year. We talked about her daughter's school play, which was a production of The Wizard of Oz, and Sylvie described the costumes in detail, and we laughed about the Tin Man's cardboard costume, and she held my hand at one point, briefly, when she was leaving. The closing was at 9 the next morning. She had arranged it. She sat with me for an hour and brought my favorite soup and did not say a word about it. I have turned that hour over in my mind many times since then. I have looked at it from every angle I know how to look at something. I cannot find in it what I would need to find to feel entirely all right about my daughter. The legal situation I resolved. That hour, I have not resolved. At 8:40 a.m., Constance Teal's office sent formal notice to both parties' counsel that the title commitment for the property at 4412, Abercorn Extension, was being withdrawn, pending resolution of a chain of title discrepancy. The notice went to Philip's office, to Bradley Covington's office, and to Ironwood's closing attorney, a man named Westbrook, who was at that moment sitting in the conference room on Bay Street preparing for a 9 a.m. closing. Westbrook called Philip at 8:52. Philip's paralegal, who handled the call, said he was professionally annoyed in the way that closing attorneys are professionally annoyed when transactions fall apart at the last possible moment, which is a specific kind of annoyed, controlled, but unmistakable, the voice of a man recalculating a day that no longer contains what he planned for it to contain. He asked whether the title issue was resolvable. Philip said it would require a corrective deed. Westbrook said he would advise his client. The call lasted 4 minutes. The closing did not happen. Garrett was in that conference room. He had flown down from Atlanta Sunday night. Philip's paralegal confirmed this, though I had not asked. And he was present when Westbrook received the call and then turned to address the room. According to the account I was given, Garrett's face went through several expressions in quick succession. What it settled on was described as the face of a man who had calculated very carefully and found that he had made an error he would not be able to immediately correct. He left the building before 9:15. He did not call me. I was discharged from Savannah Memorial 3 days later, on a Thursday morning. Dr. Krishnamurthy shook my hand and told me my numbers were excellent and that I should limit strenuous activity for 6 weeks and follow up in 30 days. I thanked him. I put on the clothes Eugenia had brought me: navy slacks, my cream cardigan, the comfortable shoes, and I signed my discharge papers, which I read twice before signing, and I waited in the wheelchair they require you to use in the lobby while Eugenia pulled her Buick LeSabre around to the entrance. She had cleaned her car for the occasion. I noticed this and said nothing about it. We drove home through the Savannah morning, past the Spanish moss and the squares and the live oaks, past the world that had been conducting itself without me for 23 days, and when Eugenia turned onto Abercorn Extension, I looked at my house through the passenger window. The yard sign was gone. I had not known it would be gone. I looked at Eugenia. She kept her eyes on the road. "When?" I asked. "Tuesday morning," she said. The morning after the closing fell through. I borrowed Ray's post-hole digger. I thought about Eugenia at 77 with a post-hole digger in her hands, pulling a developer's sign out of my front lawn at 7 in the morning, putting it in her recycling bin without ceremony. I thought about the fact that she had not mentioned it, not in any of the phone calls, not in the visit to the hospital. "You should have told me," I said. "You had enough going on," she said. "Besides," she paused, "you would have done the same." She was right. I would have done exactly the same. I went through the house room by room the first afternoon, the way I do every time I have been away for more than a few days, not checking anything in particular, just reacquainting myself with the specific weight and smell of the place, the way the light comes through the south windows in the afternoon, the particular groan of the third step on the stairs, the sound the old Frigidaire makes when the compressor kicks on. It sounds like a small sigh. I have heard that sigh every morning for 44 years. The fig tree had leafed out while I was gone. By late April, it is always beginning to fill in, and standing at the back door I could see the first flush of new growth, the bright yellow-green of the young leaves, the branches already heavy with the promise of the early crop. The tree is so large now that in full leaf it blocks the view of the back fence entirely. I stood there for a while, looking at it, in the cardigan and the comfortable shoes, with the late afternoon light coming through, and I thought, this is mine. not as a declaration, just as a fact. I met with Rosalind Guthrie Falk, my estate attorney, the following Monday. I had an appointment at her office on Drayton Street, the north-facing windows, the Tiffany lamp. And I had brought my notebook and the folder of documentation and a list of what I wanted done. I revoked the durable power of attorney I had signed in 2021. I had a new one drawn up, naming Eugenia Farrow Bates and Philip Marsh as my agents. I had the new document notarized by my own hand, pressing my own seal into the paper with the satisfaction of a woman who has made this motion 20,000 times and means every one of them. Rosalind witnessed it. Garrett and Sylvie were informed by letter through counsel. Philip's office drafted the letter, which was factual and complete and contained nothing inflammatory and did not require a response. It described the revocation of the 2021 power of attorney, the execution of the new document, and the new agents named therein. It was 2 paragraphs. I reviewed it twice before it was sent. Sylvie called 3 times the week after the letter arrived. I let the first 2 go to voicemail. The 3rd time, I picked up. We talked for 40 minutes, and it was not a comfortable 40 minutes, and I do not want to describe it here in detail, because it is private in the way that some things are private even when you are telling a story. I will say this. She did not say she was sorry for what she had done. She said she was sorry it had upset me. Those are different sentences. I have not spoken with Garrett. He has not called. I am not waiting, but I am also not closing any door that is still open. He is my son. He sent yellow roses twice. I will wait and see what kind of man he turns out to be. The corrective deed took 6 weeks to prepare. Philip's office handled it. The process involved a licensed surveyor re-establishing the correct reference point on the 1991 survey, a title company review, and the drafting of a new instrument that corrected the 1987 description and brought the chain into clean alignment. It was not simple, and it was not cheap. Philip reduced his fees substantially, which I did not ask him to do, and which I intend to repay through a donation to the Savannah Law School Scholarship Fund that Aldridge and Marsh endows, because that is the kind of repayment Philip would actually accept. The corrective deed was filed at the Chatham County courthouse on a Wednesday morning in late May. Philip's paralegal sent me a copy by email, and I printed it on the printer in the study, the little Canon that has been on that desk since 2012. And I put the printed copy in the second drawer alongside the original 1980 purchase documents. Those 2 pieces of paper are separated by 44 years. They describe the same piece of land. My name is on both of them. Ironwood Residential LLC, I learned through Philip, had moved on. They had made an offer on a different property within 2 weeks of the failed closing. I bear them no ill will. They were doing their job, working with what appeared to be valid documentation. The professional annoyance their attorney had expressed was reasonable and proportionate. Real estate is a business. Closings fail. People recalibrate. I understand that better than most. The broader question of the power of attorney, whether Garrett and Sylvie had exceeded its scope, whether their actions constituted a breach of fiduciary duty, was something Rosalind and I discussed at length. The short answer is that the law in this area is not as clear as I would like it to be, and that pursuing the matter formally would cost more than it would return, in money and in time, and in the remainder of whatever relationship I have with my children. I made a decision that is mine to make, which is that I would spend my energy correcting the record rather than litigating it. The new power of attorney names people I trust. The old one is revoked. That is sufficient. What is also sufficient? Constance Teal called me in late May, to let me know the corrective deed had recorded cleanly. She said she was glad it had worked out. I told her she had done excellent work on short notice on a weekend, and that she had my gratitude. She said, "You taught me to read the chain all the way back. I was just doing what you taught me." I told her that was the nicest thing anyone had said to me in a while. She laughed. We said we'd have lunch. I find that I mean it. It would be good to have lunch with Constance Teal. She is a serious woman. I have always liked serious women. June came warm and early in Savannah. The fig tree produced ahead of schedule, the first small figs showing by the second week of the month, and by late June I had enough to fill 6 of the half-pint cur jars with the preserves I make every year from the same recipe. Figs and sugar and a half lemon, cooked down slowly in the old enamel pot that belonged to my mother. I gave 2 jars to Eugenia. I gave one to Philip's office, which has a small kitchen, and left it there with a note that did not say anything about gratitude because Philip does not require explicit gratitude, which is one of the things I have always respected about him. The house runs on its own schedule. The Frigidaire sighs. The third step groans. The south windows fill with afternoon light from about 2 o'clock through 5, and in that window, depending on the season, I either sit on the porch with something cold to drink or move to the study where the light is different. These are not dramatic facts. They are the facts of living in one place for 44 years. Garrett called in mid-June. It was a Sunday afternoon, which I noted. I picked up. The conversation was shorter than the one with Sylvie and more careful in its language. He said he had been thinking. He said he understood that he had made decisions that were not his to make. He said, and this is the sentence I keep coming back to, that he had told himself a story about what was good for me and had not stopped to verify that story against anything I had actually said or wanted. I listened. I told him I heard him. I told him we would need some time. He said he understood. I do not know what happens next with Garrett. I have been in the world long enough to know that some fractures heal and some don't, and that the quality of the repair depends on work done over years, not over one careful Sunday phone call. But he called, and the sentence he used, the story he had told himself about what was good for me, was an honest sentence. That matters. Not enough yet, but it matters. Eugenia came for sweet tea the following Tuesday, which is when she comes, because that is the standing arrangement we have had since 2019. She brought the tea in the wide-mouth mason jars she uses because she thinks glasses are too formal for a porch, which is an opinion I have never argued with. We sat in the 2 wicker chairs that have been on that porch since 1992, and the afternoon was warm and the neighborhood was doing what it does, and we did not talk about any of it for a long time. We talked about Eugenia's granddaughter, who has gotten into Georgia Southern on a partial scholarship and plans to study veterinary science. We talked about the Thai restaurant on Bull Street and whether it was as good as the reviews said. We talked about the weather. Not talking about something, when you are sitting with someone who knows everything about it, is its own kind of conversation. I am grateful to Eugenia for understanding that. I am grateful for many things about Eugenia, but that particular understanding is the one that cost her the most to have, and the one she has offered me most freely. It is September now, and the fig tree is in its second bearing. The late summer fruit is always different from the June crop. Smaller, sweeter, the skin more papery, and the flesh a deeper burgundy. The kind that comes off the branch with a small resistance and then lets go all at once. I picked 2 pounds of them on a Thursday morning, standing in the backyard in the early light with the dew still on the grass. And I thought about Dolores Cantwell Reese, who told me in 1980 to water the tree deep in August, and about how long it takes for a thing to become itself. I have a file on my desk in the study. It contains the 1980 purchase documents and the corrective deed filed in May, and a printed copy of the chain of title as it now stands. Clean, current, annotated in the margins in my own handwriting. I am the kind of woman who annotates. I have been the kind of woman who annotates since 1975. I opened the folder that morning and took out the deed. It is a standard instrument, 2 pages, the legal language dense and specific and entirely comprehensible if you know how to read it. The metes and bounds description is correct, corrected now as of late May with the proper survey reference point, and the chain cleared all the way back to 1941. My name appears in the granting clause. Harriet June Alderman Poole. The property address follows. The legal description follows. The notary seal is there, clean and clear. I read my own name in the legal description. I know what this document says. It says the house is mine, not as a sentiment, not as a declaration, but as a recorded legal fact in the Chatham County public record. It says I am the fee simple owner of a 1940s craftsman bungalow at 4412 Abercorn Extension, assessed at $340,000, with a fig tree in the backyard that I planted in 1980, and a front porch with 2 wicker chairs and heart pine floors that groan in the same spots every morning. I put the deed back in the folder. I closed the folder. I set it in the second drawer of the desk, where the 1980 documents have been for 44 years. Then I picked up my phone. I went to the folder labeled with the date from 17 days into my hospitalization. The folder I had created at 4:17 on a Tuesday afternoon in a hospital room with a heart monitor still on my chest. I opened it. I looked at the photograph one final time, my front porch, my fig tree at the edge of the frame, the developer's sign in the lawn. I deleted it. I closed the folder. I am not a woman who keeps documents she no longer needs. The matter is resolved. The record is clean. The house is mine. I got up from the desk and went to the kitchen to make coffee, and the Frigidaire sighed when I opened it, the way it has sighed every morning for 44 years. And the September light was coming through the south window at an angle that meant I had about 2 hours before I should sit on the porch, and there was nothing to do about any of that except be grateful for it. I was. I am. I know what this house says. It says I live here. Friends, Harriet didn't rage, didn't break down. She opened a folder and called the right people. Honestly, I'd have done the same, but I don't know if I'd have stayed that calm. The soup from Sylvie is the part I keep coming back to. If this story stayed with you, subscribe and leave a comment. It genuinely keeps this channel alive, and these women deserve to be heard.